honorable judges, learned friends and colleagues, good afternoon. So, taking on from your question, I think there's been a lot of focus on upstream issues, upstream contracts, and how arbitrations and mediations and negotiations are a good form of dispute resolution mechanisms there. Now, those are issues, naturally, there's a similar bargaining power when these contracts are being entered into and the parties opt for arbitration as a preferred method. There are international arbitrations, and certainly we'd like to see more local arbitrations as and when that system is formalized in Pakistan with specific rules, and because a lot of confusion with ad hoc arbitrations today is that an arbitration clause would provide for appointment of an arbitrator, but the arbitrator would not know what rules to follow, whether evidence is to be recorded and so on and so forth. But leaving that aside, the vast majority of energy sector disputes that come to the courts are between the end consumer and a supplier. Now, this happens in the case of power distribution companies, the DISCOs, and also in the cases of OGRA licensees, so who are providing natural gas to the consumers. Now, up till 2018, there was no alternative method of dispute resolution when it came to electricity matters. So if anyone had an issue, they would go to a court and they'd try to get their grievance agitated. The only exception was that in the Electricity Act of 1910, for a billing dispute, a person could approach a provincial authority called an electric inspector. Naturally, the awareness wasn't there. A lot of people would not know that they have to approach there, and they'd end up approaching the courts, and their cases would be returned on the ground that you have to go there and you have to get it resolved, and they have the technical expertise. When the NEPRA Act came in, NEPRA as a regulator had the power to entertain complaints of all types of disputes. So if a consumer has a billing dispute, it has a dispute in relation to a tariff that NEPRA has issued, all those disputes can be taken over to NEPRA under the relevant provision, which is Section 39. Now, what happened was that once NEPRA had made a determination, there was no avenue for the consumer. So a consumer, or in fact a licensee, would then approach the courts, either in the writ jurisdiction or the original side, and they'd agitate their grievance. Now, some of the disputes, naturally, they would involve a question of law, but a lot of them were very highly technical issues. And when it pertained to tariffs, there was a lot of finance involved. In 2018, the NEPRA Appellate Tribunal was formed. And the Appellate Tribunal is to comprise of a chairman, who is to be a retired judge of the High Court, a person with a financial background, so a finance member, and a technical member, preferably an electronic engineer. In 2018, even though the law came in, the federal government did not appoint the tribunal. And it was in 2020 that the Supreme Court, in a suo motu action, had to direct the government to appoint the tribunal. The tribunal was appointed, but till today, there's no member finance in the tribunal. So there's literally no expertise. Now,
let me stop you there. So you've just outlined what is a very real difficulty and a challenge that needs to be overcome. How would you suggest that we overcome that in Pakistan?
I mean, I think this amendment in the law is a very good amendment. It's a welcome change because you have created a specialized tribunal, but there has to be seriousness from the government side as well. We need qualified people on the tribunal. When people now go to the courts, naturally they're turned down. There's a recent judgment of the Supreme Court which says that in these technical disputes, we're not going to intervene. But the alternative, the dispute resolution mechanism, has to be proper. Although there is an appeal provided to the High Court, and I'm sure a lot of appeals would come in if those members are not properly appointed and the determinations are not correct, I think that is the right way to go. But you see, there are other types of disputes. Small billing disputes, less than 200,000 rupees. People are coming to the courts in the writ jurisdiction, they're trying to get their bills corrected, and that creates a lot of burden on the courts. Now, NEPRA under Section 39 can entertain those complaints, but unfortunately, it's based in Islamabad. There is no regional office in the different regions, a person sitting in Ghotki, if he has a dispute with his disco, how will he approach NEPRA? There are no timelines provided how the complaint is going to be resolved. That person ultimately would end up in a civil court, which is right there. Even if he goes to a lawyer, the lawyer can't go to Islamabad because for such a small dispute, the traveling cost alone would be higher than the disputed amount. So these are things that need to be worked at. There are certainly good alternative dispute resolution mechanisms provided under the law, but we need to implement those laws, and the government needs to be serious. The third type of issues, and this is something that in the recent past, what I've seen is that a lot of disputes arise from a tariff issued by NEPRA or a determination given by OGRA in gas disputes. And the dispute primarily arises because of a government policy to either reduce a subsidy which was being given or on the basis of a policy guideline issued by the government. Now, these authorities claim that they are bound by these government guidelines. And once that is incorporated, under the gas disputes, naturally there is no other avenue for them to go. They have to go to the courts. Currently, there is no other dispute resolution mechanism. If there's a billing issue, a bill correction issue, or in relation of terms and conditions, there are regulations of 2003 and they can approach OGRA. But for a matter where a subsidy is involved, so a government policy mandated subsidy is involved, there is no avenue in gas. And as far as electricity is concerned, that tribunal needs to be functional properly, and there have to be timelines when these disputes are decided, because the entire industry, if they are going to export goods abroad, if they're going to compete with international markets, they first of all need certainty, and secondly, if that certainty is not there, a decision has been passed, it needs to be decided very quickly, so that we as a country can compete internationally as well, and these alternative dispute resolution mechanisms are properly implemented in that way.
Thank you.